Copyright, Copyleft and the Creative Anti-Commons, by Nimus. Part 4, The Creative Anti-Commons Compromise. The dissidents of intellectual property have had a rich history among avant-garde artists, zine producers, radical musicians, and the subcultural fringe. Today the fight against intellectual property is being led by lawyers, professors and members of government. Not only is the social strata of the leading players very different, which in itself might not be such an important detail, but the framework of the struggle against intellectual property has completely changed. Before law professors like Lawrence Lessig became interested in it, the discourse among dissidents was against any ownership of the commons, intellectual or physical. Now center stage is occupied by supporters of property and economic privilege. The argument is no longer that the author is a fiction and that property is theft, but that intellectual property law needs to be restrained and reformed because it now infringes upon the rights of creators. Lessig criticizes the recent changes in copyright legislation imposed by global media corporations and their powerful lobbies, the absurd lengths to which copyright has been extended, and other perversions that restrict the creativity of artists. But he does not question copyright as such, since he views it as the most important incentive for artists to create. The objective is to defend against its extremism and absolutism, while preserving its beneficial effects. In his keynote at Wizards of Oz 4 in Berlin, Lessig celebrated the red-right culture of free sharing and collaborative authorship that has been the norm for most of history. During the last century, this red-right culture has been thwarted by its legislation and converted to a red-only culture dominated by a regime of producer control. Lessig bemoans the recent travesties of copyright law that have censured the work of remix artists like DJ Danger Mouse The Grey Album and Javier Prato Jesus Christ, the musical. Both were torpedoed by the legal owners of the music used in the production of their works, as were John Oswald and Negativland before them. In these cases the wishes of the artists, who were regarded as mere consumers in the eyes of the law, were subordinated to control by the producers the Beatles and Gloria Gaynor, respectively, and their legal representatives. The problem is that producer control is creating a red-only culture and destroying the vibrancy and diversity of creative production. It is promoting the narrow interests of a few privileged producers, at the expense of everybody else. Lessig contrasts producer control to the cultural commons, a common stock of value that all can use and contribute to. The commons denies producer control and insists on the freedom of consumers. The free, in free culture refers to the natural freedom of consumers to use the common cultural stock and not the state-enforced freedom of producers to control the use of their work. In principle, the notion of a cultural commons abolishes the distinction between producers and consumers, viewing them as equal actors in an ongoing process. Lessig claims that today, as a result of commons-based peer production and the Creative Commons project more specifically, the possibility of a red-right culture is reborn. But is the Creative Commons really a commons? According to its website, Creative Commons defines the spectrum of possibilities between full copyright, all rights reserved, and the public domain, no rights reserved. Our licenses help you keep your copyright while inviting certain uses of your work as some rights reserved copyright. The point is clear: Creative Commons exists to help you, the producer, keep control of your work. You are invited to choose among a range of restrictions you wish to apply to your work, such as forbidding duplication, forbidding derivative works, or forbidding commercial use. It is assumed that as an author-producer everything you make and everything you say is your property. The right of the consumer is not mentioned, nor is the distinction between producers and consumers of culture disputed. Creative Commons legitimates, rather than denies, producer control and enforces, rather than abolishes, the distinction between producer and consumer. It expands the legal framework for producers to deny consumers the possibility to create use value or exchange value out of the common stock. Had the Beatles and Gloria Gaynor published their work within the framework of Creative Commons, it would still be their choice and not the choice of DJ Danger Mouse or Javier Prato whether the Grey Album or Jesus Christ. The musical should be allowed to exist. The legal representatives of the Beatles and Gloria Gaynor could just as easily have used CC licenses to enforce their control over the use of their work. The very problem of producer control presented by Lessig is not solved by the Creative Commons. Solution: as long as the producer has an exclusive right to choose the level of freedom to grant the consumer, a right that Lessig has never questioned. The Creative Commons mission of allowing producers the freedom to choose the level of restrictions for publishing their work contradicts the real conditions of commons-based production. Lessig's use of DJ Danger Mouse and Javier Petro as examples to promote the cause of Creative Commons is an extravagant dishonesty. A similar dishonesty is present in Lessig's praise of the free software movement because its architecture assures everyone technologically as well as legally, in the form of its licenses, the possibility to use the common resource of the source code. Despite its claim to be extending the principles of the free software movement, the freedom Creative Commons gives to creators to choose how their works are used is very different from the freedom the GPL gives to users to copy, modify and distribute the software as long as the same freedom is passed down. Stallman recently made a statement rejecting Creative Commons in its entirety because some of its licenses are free while others are non-free, which confuses people into mistaking the common label for something substantial when in fact there's no common standard and no ethical position behind the label. Whereas Copyleft claims ownership legally only to relinquish it practically, the references to ownership by Creative Commons is no longer an ironic reversal but real. The pick and choose CC licenses allow arbitrary restrictions on the freedom of users based on an author's particular preferences and tastes. In this sense, Creative Commons is a more elaborate version of copyright. It doesn't challenge the copyright regime as a whole, nor does it preserve its legal shell in order to turn the practice of copyright on its head, like Copyleft does. The public domain, anti-copyright and Copyleft are all attempts to create a commons, a shared space of non-ownership that is free for everyone to use. The conditions of use may differ, according to various interpretations of rights and responsibilities, but these rights are common rights and the resources are shared alike by the whole community. Their use is not decided arbitrarily, on a case-by-case basis, according to the whims of individual members. By contrast, Creative Commons is an attempt to use a regime of property ownership copyright law to create a non-owned, culturally shared resource. Its mixed bag of cultural goods are not held in common since it is the choice of individual authors to permit their use or to deny it. Creative Commons is really an anti-commons that peddles a capitalist logic of privatization under a deliberately misleading name. Its purpose is to help the owners of intellectual property catch up with the fast pace of information exchange, not by freeing information, but by providing more sophisticated definitions for various shades of ownership and producer control. What began as a movement for the abolition of intellectual property has become a movement of customizing owners' licenses. Almost without notice, what was once a very threatening movement of radicals, hackers and pirates is now the domain of reformists, revisionists, and apologists for capitalism. When capital is threatened, it co-opts its opposition. We have seen this scenario many times throughout history. Its most spectacular example is the transformation of self-organized workers' councils into a trade union movement that negotiates legal contracts with the owners of corporations. The Creative Commons is a similar subversion that does not question the right to private property but tries to get small concessions in a playing field where the game and its rules are determined in advance. The real effect of Creative Commons is to narrow political contestation within the sphere of the already permissible. While narrowing this field of contestation, Creative Commons simultaneously portrays itself as radical, as the avant-garde of the battle against intellectual property. Creative Commons has become a kind of default orthodoxy in non-commercial licensing, and a popular cause among artists and intellectuals who consider themselves generally on the left and against the IP regime in particular. The Creative Commons label is moralistically invoked on countless sites, blogs, speeches, essays, artworks and pieces of music as if it constituted the necessary and sufficient condition for the coming revolution of a truly free culture. Creative Commons is part of a larger copy fight movement, which is defined as a fight to keep intellectual property tethered to its original purpose and to prevent it from going too far. The individuals and groups associated with this movement: John Perry Barlow, David Bollier, James Boyle, Creative Commons, Free Culture Org, Larry Lessig, Jessica Littman, Eric Raymond, /.org advocate what Boyle has called a smarter IP, or a reform of intellectual property that doesn't threaten free speech, democracy, competition, innovation, education, the progress of science, and other things that are critically important to our social, cultural, and economic well-being. In an uncanny repetition of the copyright struggles that first emerged during the period of Romanticism, the excesses of the capitalist form of intellectual property are opposed, but using its own language and presuppositions. Creative Commons preserves Romanticism's ideas of originality, creativity and property rights, and similarly considers free culture to be a separate sphere existing in splendid isolation from the world of material production. Ever since the 18th century, the ideas of creativity and originality have been inextricably linked to an anti-commons of knowledge. Creative Commons is no exception. There's no doubt that Creative Commons can shed light on some of the issues in the continuing struggle against intellectual property, but it is insufficient at best, and, at its worst, it's just another attempt by the apologists of property to confuse the discourse, poison the well, and crowd out any revolutionary analysis. Attribution. This text developed out of a series of conversations and correspondences between Johann Richardson and Dmitri Kleiner. Many thanks to all who contributed to its production: Saul Albert, Mikhail Bakunin, David Berry, Critical Art Ensemble, Johann Gottlieb Fichte, Michel Foucault, Martin Fredriksson, Marci Hamilton, Carla Hesse, Benjamin Mako Hill, Stewart Home, Dan Hunter, Mark Lemley, Lawrence Lessig, Karl Marx, Giles Moss, Milton Mueller, Piratbyran, Pierre-Joseph Proudhon, Toni Prug, Samuel Richardson, Patrice Remans, Mark Rose, Pamela Samuelson, The Situationist International, Johann Soderberg, Richard Stallman, Catherine Temple, Benjamin Tucker, Jason Toynbee, Tristan Tsara, Wikipedia, Martha Woodman C. Wuming, Berlin, 2006. Anti-copyright, all rights dispersed.